Hi everyone. Let's talk today about the administrative law concept known as the Chenery Doctrine. So this goes all the way back to the 1940s. If you're an administrative law student, you probably are going to read these cases. They're very long. There's a lot of facts that go into them, particularly the first one, and a lot of other substantive law that plays a role. And I kind of want to just break down what the principles from the holdings of those cases are, because they can be confusing to read, but they come with some fairly straightforward principles, some doctrine that's pretty easy to understand, and that is extremely important in the context of administrative law. So Chenery 1, SEC versus Chenery Corp. Was decided in 1943. It was a 4-3 decision. So as you can see, there were two justices who were not handling the case. They probably recused themselves. And the majority opinion was written by Justice Frankfurter. So basically what had happened was the SEC crafted an order, and in that order, they got fiduciary duty wrong. They basically based the order on substantive law that was poorly understood. They didn't understand the law that they were citing. And this was extremely problematic when the order got all the way up to the Supreme Court. So Justice Frankfurter wrote that the order cannot be sustained. It's relying on judicial decisions which don't support it, and the basis for it is just crummy, like it cannot work. So it was remanded to the SEC to handle it. The dissent was Justice Black. Justice Black said that he thought that the order was consistent with the high standards that we hold fiduciaries to, but his view didn't win the day. So the order gets remanded in 1943 with the Supreme Court's decision in Chenery 1. So the basic principle of Chenery 1 is that courts cannot invent new principles to sustain an agency action on. Lower court judgments can only be sustained on the grounds that were specifically relied upon by the agency. An agency's decisions can only be sustained on the grounds that were specifically relied on by the agencies. Courts cannot just accept the post hoc rationalizations from appellate counsel in order to sustain agency actions. So this applies both to rulemaking and to adjudication. So the basic idea is that the agency action gets challenged. The agency relied on A, B, C, D, and E as bases for the action. So appellate counsel can't just say when they're arguing to the judge, Your Honor, I think that this order should be sustained on the grounds of X, Y, and Z, and not even mention A, B, and C, and D. So they can't just invent post hoc rationalizations. They have to argue for it on the grounds that the agency argued on it for. So in that sense, it kind of hampers the creativity of appellate counsel, but it also makes sense because we want to know what the agency was thinking at the time that it issued the order. So that's the major policy concern for Chenery 1. One thing that's interesting, according to Gary Lawson, parties that seek affirmation of agency decisions actually violate the Chenery 1 principle fairly frequently. They invent new grounds, post hoc rationalizations that they argue for in front of the court, and obviously they don't tend to be super successful, but sometimes they do slip past the court. This played a key role, the Chenery 1 principle, recently in the decision of Department of Homeland Security versus Regents of the University of California in 2020. If you want to check that case out, it's an interesting example. It involved DACA, and of course it took place during the Trump years. So then we get to Chenery 2. So 1943 has passed. The order has come back to the Supreme Court in 1947, and the SEC has revised it. Justice Murphy writes a majority opinion in a 5-2 decision. Obviously, some members of the Supreme Court not there again this time. And Justice Murphy is really praising the order. He says that it got rid of its fatal flaw where it misunderstood the judicial decisions it relied on. It's much better this time. It's viable. And yeah, it's fine. The agency didn't need to do rulemaking for it either. It doesn't matter that it's retroactive. And overall, it can be sustained. And yeah, so while this decision was a victory for the agencies, what's kind of funny is that we see Justice Jackson joined by Justice Frankfurter, the author of Chenery 1 in the dissent. And Justice Jackson writes a funny quote about the majority's opinion, criticizing it, saying, "The court's reasoning adds up to this. The commission must be sustained because of its accumulated experience in solving a problem with which it had never been confronted. I give up. Now I fully realize what Mark Twain meant when he said, 'The more you explain it, the more I don't understand it.'" So what he was getting at here was how Justice Murphy was probably being a little overly deferential to the agency, saying that this is a novel problem, but also the agency has tons of experience. So on the one hand, praising the agency for experience while also saying the agency has no experience with this particular issue. So it's really interesting and kind of entertaining in case you thought that Supreme Court justices didn't act petty back in the 1940s. They did, and it was really funny to read. But yeah, so Chenery 2 basically stands for the principle that the decision between rulemaking and adjudication is primarily left to the agency's discretion. The agency gets to choose whether or not to make rules or whether to adjudicate. And courts don't have very much of a role in deciding whether or not that's within the agency's discretion. The courts still are empowered to overturn agency decisions if they find that their choice between rulemaking and adjudication was an abuse of discretion. But generally, if a challenger is upset and decides to bring an agency choice based on whether or not they made rules or adjudicated to court, the challenger is going to have a very, very hard time winning. Courts have, over the years, been really reluctant to use some of the openings that were left by Chenery 2, that they can overturn decisions as being an abuse of discretion. They generally give agencies a lot of discretion. Now, obviously, you kind of have to wonder, with the new, more conservative Supreme Court, will things take a different turn? Will the more conservative Supreme Court that we have in 2024 say that Chenery 2 principles need to be tempered, that agencies don't have as much discretion as they had before in rulemaking and adjudication? And yeah, part of the reason that agencies might be more inclined under Chenery 2 to choose to do adjudication rather than rulemaking is that in the context of informal adjudication, there are basically zero procedural requirements, whereas in the context of informal rulemaking, the agency does have some procedural requirements. They still need to adhere to the notice and comment requirements of Section 553 of the Administrative Procedure Act. So yeah, when they have less procedural requirements under the APA to do rulemaking, or to do adjudication, they're probably going to favor doing adjudication over rulemaking. So that's one of the reasons that it's common for challengers to complain that the agency did adjudication instead of rulemaking. But as of yet, it seems like those types of challenges are generally not successful. So in summary, Chenery 1 was the anti-agency decision, which stood for the idea that you can't, as an appellate counsel for an agency, make new grounds for the agency's decision. Courts cannot rely on it. And meanwhile, Chenery 2 was the pro-agency decision, and it says that agencies generally have a lot of discretion in their decision to make rules and to adjudicate, although that discretion is, of course, not unlimited. So yeah, that's Chenery 1 and that's Chenery 2. They're really dense cases with a lot of facts leading up to them, but I hope that I simplified them down because there's something that's quite likely to come up in like an issue spotter for an administrative law final. They're probably going to continue to be relevant in today's day and age. And yeah, overall, landmark decisions. We will see what happens with them going forward. But yeah, if you found this video helpful, which I hope you did, please leave a like, comment, and subscribe. I hope to have many more videos on administrative law going forward, and I will see you in the next video. Thank you.